As an employment lawyer in Arizona, I have met with countless employees to discuss their situation and determine if they have claims against their current or past employers. From those meetings, I have prepared a list of 10 common questions that I get asked. First question, do you think that I was subject to a hostile work environment? The term hostile work environment is the most commonly misused phrase I hear when meeting with potential clients. This is actually a legal term of art that only comes to life when an individual is subject to offensive and unwelcome conduct based on their protected status, such as their race, gender, nationality, or religion. And that conduct is so severe or pervasive that it affects the terms and conditions of your employment. If someone at work is mean just for the sake of being mean, then that does not constitute a hostile work environment in the legal sense. Question number 2. When does an employer have to pay me after I quit or I am fired, and can an employer withhold my payment? An employer who is discharged from employment must be paid within 7 working days or the end of the next regular pay period, whichever is sooner. Employees who quit must be paid by the next regular pay day. An employer can withhold wages, but only if the employer is allowed to by law or has authorization from an employee to do so. Or the last way they can do that is if they have a reasonable good faith dispute as to the amount of wages due, including the amount of any counterclaim or any claim of debt, reimbursement, recoupment, or set-off. Question number 3. What is the process if I want to make a claim against my employer? This may depend on the type of claim you have. If you have a claim for discrimination, you may need to file a charge with the Equal Employment Opportunity Commission or the Arizona Civil Rights Division. If you have a claim for unpaid wages, then you may need to file a claim in state court or federal court. Other claims have other administrative agencies that you must notify, such as the National Labor Relations Board or the Occupational Safety and Health Administration. If you have questions, come talk to us here at Denton Peterson. Fourth question, how do I file for unemployment benefits? The Arizona Department of Economic Security has information for individuals looking to file unemployment claims. Their website is extremely helpful and easy to use. I'd recommend you go there first. Question number 5, is my non-compete agreement enforceable? This largely depends on the contractual language of the non-compete agreement itself. In short, the non-compete agreement needs 3 things. 1, a reasonable limitation on the type of work an employee can perform. 2, a reasonable geographic scope. And 3, a reasonable time duration. This is a fact-intensive analysis that we can help you review here at Denton Peterson Law Firm. Question number 6, what do I tell a prospective employer if I was fired improperly from my last job? This can be a very touchy subject, especially when an employee feels as though they were wrongfully terminated or terminated under false pretenses. It is always important to be honest, but it is also important not to allow your previous employer to shape your future dialogue about what transpired. For example, if your previous employer terminated you for poor performance, but you believe it was because you reported wrongdoing, then you don't have to just say that you were fired because you were underperforming. You can say that you were terminated for reporting wrongdoing. Question number 7, can my past employer contact my new employer for anything? Well, this seems like an odd question. When an employee feels that they have been wrongfully terminated, it often seems, and is sometimes true, that an employer is out to get them. It is possible for past employers to contact a new employer, but that employee may have claims for defamation or tortious interference depending on what is said. However, it is my experience that most past employers do not actively reach out to new employers. Question number 8, does my employer have to use progressive discipline before termination? Arizona is an at-will employment state, so the short answer is no. However, if an employer has a practice of utilizing progressive discipline, but does not do so in your case, then it may be evidence of an underlying discrimination based on your protected class status. Question number 9, how much do you think I will get if I file a claim? Some claims have a definitive amount that can be determined after an initial consultation. Other claims are not so easily calculated because they have certain intangible damages like emotional distress that will likely require much more time to determine. We will work with you to get a better understanding of what amount you may be owed. What does it cost to have you represent me is the final question that I get asked. Money is understandably on the top of every client's mind as they recently lost their job. Unfortunately, employment lawyers largely charge hourly rates for the services you receive. In some cases, flat fee representation is available. Be careful, however, not to simply choose the cheapest attorney because you don't want to spend money, and not to choose the most expensive attorney just because you think they will be good. Trust your instincts when meeting with an attorney to see if you should choose them and their firm. While clients do have other questions, this rounds off the top 10. If you have these questions or have follow-up questions about your employment law issues in Arizona, please contact me at Denton Peterson Law Firm.